Okay, the week 2 video. We are, for the most part, in the week 2 video, going to be dealing with the legal aspects of HR. In fact, the legal aspects never really leave us. We tend to talk about the legal aspects to some degree in most weeks, but we talk about them mostly here in this first week. Once again, not trying to go over all the ins and outs of the legal aspects, but just point out some of the major topics here in week 2. Before we get to the legalities, though, let's look here at HR planning. One of the functions of HR is this notion of HR planning. You see there it's the process of analyzing and identifying the need for and availability of HR, such that an organization can meet its objectives, has the following two components, the external and internal. And let's actually take these in reverse order. Let's talk about the internal component first. The whole notion of HR planning is this. As an organization, what are your strategies? What are your goals? What are your objectives? What is it that you're wanting to accomplish? Based upon what you're wanting to accomplish, what types of workers, in terms of how many, what skills are going to be needed? That is the internal component, right? So in terms of what your organization is wanting to accomplish, what types of workers are you going to need? How many of those workers? What skills do they need? Just think about any task, right? If you are building a bridge, a company's going to say, okay, we're building a bridge. So, how many workers are we going to need to build that bridge? What types of skills are they going to need to have? So that is essentially the internal component. Now, obviously, as an organization, in many cases, you're already going to have those employees. In fact, you may find that you have more employees than you need. We will talk about that in a later chapter. You may indeed have to downsize. That is certainly a last resort. And if you do have to downsize, there are some humane ways of going about that, namely through things such as attrition. Basically, if you just give people plenty of lead time, you can have folks who naturally leave an organization through retiring or finding other jobs, and so essentially you can downsize in a way such that no one loses their job who really wants to stay. But that's assuming you have a lot of lead time to do those types of things. Anyway, that's sort of the worst case scenario. So if that is the case, that you have more employees that you need, there are some hopefully some civil ways you can go about downsizing. But in many cases, organizations find that they actually do not have the skills that are needed, that there's a shortage of certain skills. In that case, that brings us to the external component. In other words, what skills are available? So given what our strategy is, given the types of skills we need, what types of skills are available in the external environment, in the labor force? And there's a variety of factors that affect that. So that's HR planning. What do we need and basically what is out there? Brings us to equal employment opportunity, EEO. We've all heard this concept of EEO. The first thing I really want to say is that equal employment opportunity is not a law per se. It is not a specific law per se. It is a goal. It is an ideal. It is something that the government set out to achieve about 50 years ago. About 50 years ago, there was this notion of we want equal employment opportunity. And so actually, it's a body of laws. It's a number of different laws that have been written with the goal of achieving equal employment opportunity. Most people, when they think about equal employment opportunity, they think about hiring, the hiring decision. But as you see here, equal employment opportunity is about all employment-related actions. Hiring, raises, promotions, discipline, terminations, etc., etc. Currently, these are the major groups of individuals that are afforded protection in our particular country. And this is based on federal law. So based on the federal laws that have been passed to date, groups are protected based on the following: race, ethnic origin, and color. And it actually goes a little beyond that. It goes to nationality. It goes to citizenship as well. Non-citizens in the U.S. Who can legally work here, right? So they have the proper visas, etc. They are protected as well. Gender, you cannot be discriminated against based on your gender. You cannot be discriminated based on your age. For those 40 and over, so if you're, a company decides they don't want to hire you because you're 33, you do not have a case. So individuals with disabilities, military experience, that one's kind of a quirky one. Just because you served, maybe for a couple years in the Navy or something like that, doesn't necessarily protect you. We won't get into all the ins and outs of that. But generally, military experience is protected. And then lastly, religion. So there we go. Those are the major groups that are protected in our country. It was not one law that created all these groups. In fact, it was a number of different laws that laid these out. The most significant or largest law, if you will, was the Civil Rights Act of 1964. And the Civil Rights Act of 1964 laid this one out: race, ethnic origin, and color, gender, and religion. All three of those were contained in that original law, Civil Rights Act 1964. Age, disabilities, and military experience kind of came later on. Let me clear up something. I think there's very much a misconception as far as these different groups go. A lot of people think when they see race, ethnic origin, and color that only pertains to African Americans or Hispanics, or when they see gender, they think that only pertains to women. That is not true at all. You are protected based on your race, ethnicity, and color of your skin. That does not matter if you are Caucasian, African American, Hispanic, right? Gender is protected. That is true whether you are male or you are female. The whole point of these is that companies, when they make decisions, they are not supposed to factor these in at all. That is the whole purpose of the Equal Employment Opportunity, is they're not supposed to factor in race, ethnic origin and color, gender, a person's age if they're 40 and over, disabilities, military experience, religion. The whole purpose of this is not to protect certain groups. It's to protect all groups, to force companies to not look at these. Now, some of you may be thinking, wait a second, this guy's crazy, because some companies, don't they give preferential treatments to certain groups? Well, you're probably thinking of something called affirmative action. And we don't really talk much about affirmative action in this class, but affirmative action is different than equal employment opportunity. Affirmative action pertains to a smaller set of companies. Equal employment opportunity applies to many, many companies. Not all companies, but equal employment opportunity applies to many companies. Affirmative action applies to a smaller number of companies. And you are correct. Affirmative action does require that companies take proactive measures to hire individuals of certain groups. Affirmative action does not require companies to hire people of certain groups. It just requests and asks that companies take proactive steps. Equal employment opportunity, though, totally different. Equal employment opportunity says we will be blind to a person's color or gender, age, disabilities, military experience, religion. So you're not supposed to take those into consideration. As you see, states have added to these groups. These here were based on federal law. Some states, most states have these same groups, okay? Most states have these same groups, but some states have added to these groups as well. So in some states, they have added sexual orientation as well. So in certain states, in addition to these, in those particular states, you also cannot discriminate based on sexual orientation. You cannot factor that in at all in decisions. Now, one thing I think that people are confused about these is they think, okay, well, if a person is a, let's say a 70-year-old female, that means you have to hire them. Absolutely not. You do not have to hire someone who's a 70-year-old female. If you have a 26-year-old male, and that 26-year-old male is more qualified for the job, then by all means you have every right to hire that 26-year-old male. But once again, it must be on their ability to perform the job, and their race, gender, age, etc. cannot factor in whatsoever. Important to note here that the word discrimination means that choices are made based upon differences. The word discrimination itself simply means to make choices based on differences. So when you hire someone to be a chef and you hire based on their ability to cook, you have actually discriminated. You have discriminated based on their cooking ability. That in and of itself is okay. What we want to eliminate as a company is something called illegal discrimination. Illegal discrimination is when you hire based on race, gender, age, etc. So you can discriminate based on job-related factors. You want to stay away from these non-job-related factors for legal reasons, but also just makes good business sense. If you're hiring based on gender, race, age, and you're letting that factor in, you're probably not making good decisions. Okay, disparate treatment versus disparate impact. I'm not going to go into all the ins and outs of that here. That can take a while. But I will say that this disparate treatment is a type of discrimination that we tend to think of when we hear that, hey, Bob wasn't hired for that job because he's in a wheelchair. Well, that's disparate treatment. We treated Bob differently because he was, in the wheelchair. Disparate impact is different. Disparate impact is actually discrimination that results from treating people the same. And I know that's really strange, but companies can actually be found guilty of discrimination even when they're treating people the same. There's a case that's cited in your book. It's a landmark case. It's Griggs versus Duke Power. I believe the year was 1971. In that particular case, Duke Power Company decided that they were going to have a standard, a requirement that folks have high school diplomas to get certain promotions, pay raises, etc. Well, they held that standard equally to everyone. Okay, so the high school diploma applied equally to everyone. It applied to African Americans, it applied to Hispanics, it applied to Caucasians. Well, normally, prior to 1971, Duke Power would be fine. They would be in the clear because the courts would say, look, they're applying that standard equally to everyone, and so there's no disparate treatment, right? They're applying it equally to everyone. But the Supreme Court said, yeah, they are applying it equally to everyone. However, it's not a job factor. It's not a requirement that truly is job related. Whether a person had a high school diploma for these particular type jobs made no difference in a person's ability to perform them. So the only effect that job requirement did and had was to eliminate certain groups. Certain groups of individuals were not able to do the job. Specifically, certain racial groups. And if you think about 1971, we were coming off of a period of segregation, and so African Americans had been denied the ability to get high school degrees just based on segregation and factors like that in the South. And so disparate impact, this notion that even if a job requirement is held equally, it can still discriminate. If certain groups are impacted by it, number one, and number two, if that particular job requirement is not job related. So what we're saying is, had high school diploma been necessary for doing the job, right? If Duke Power Company could have shown, look, but you really do have to have a high school diploma, then Duke Power would have been okay. Well, that brings us to this next point here, and that is, so how do we determine if something is job related? If the Duke Power Company in 1971, if the Griggs versus Duke Power says, look, something must be job related, then how do we do that? Well, we do that through a process called validation. Validation is also all about showing that a job requirement is job related. Well, the first thing you see here is content validity. Content validity is very, very straightforward. If a job requirement, if in the hiring process someone is asked to do something or asked a question, and what they're asked to do is actually part of the job itself, then that's a work sample. And so it has content validity. In other words, if you're hiring someone to be a chef, and during the hiring process you ask that person to cook you something, well, is that job related? right? Is that job related? Can that person come back later and say, well, I don't know why they asked me to do that. That didn't make sense. Of course it's job related. If you ask someone who's applying for the job of a chef to cook you something, that's very much job related. That is certainly an acceptable way to screen people. If someone is applying for the job of a welder and you ask them to weld something for you to show you how they would do that, that is certainly acceptable. That's part of the job. So you see how content validity, when you ask somebody to actually perform part of the job, that is certainly an acceptable hiring process. That is very, very different than what Duke Power did. Duke Power asked a person merely if they had a high school diploma. And having a high school diploma is not necessarily indicative of their ability to perform the job. Well, what about number 2 here, criterion-related validity? Well, some of you right now, you're kind of scratching your head and you're saying, wait a second, my particular company, we require people to have bachelor's degrees, so are we going to get in trouble? And many of you have obviously seen job postings that required master's degrees or bachelor's degrees or high school degrees. Well, how can they do that? Didn't this Griggs versus Duke Power show that we can't do that? Well, not necessarily. The problem wasn't that the problem wasn't that Duke Power asked for a high school diploma. The problem was that Duke Power asked for people to have a high school diploma, and yet high school diploma didn't matter. It did not predict performance. In other words, if high school diploma had predicted performance, then they would have been able to use it. Okay, it would have been fine. Duke Power would have been fine. Well, that's what this next one here is about, criterion-related validity. It is about showing that things like high school diploma or college diploma, or that a person have a certain personality type or pass a math test. This criterion-related validity is about showing how high school diploma, college diploma, personality, how they are related to job performance. Specifically, we see here predictive and concurrent. Suppose that you believe that the high school diploma does predict job success. Well, what you could do is you could follow some applicants after they were hired, some who had high school diplomas and some who did not. You could follow them, 3 months down the road, 6 months down the road, and see who performed best. And if our high school diploma folks perform best, then voila, that is predictive validity. Those who had the diplomas perform better. Another way, kind of a quick and easy way to do it, is something called concurrent validity. You can take your current workers, you know who your top performers are, who your low performers are. Theoretically you do, right? You have your performance appraisals. And then out of those folks who are your top and lower performers, you can see which ones have high school diplomas and which ones do not. If those with the high school diplomas perform better, then there you go. We have concurrent validity. And so you're all set. And see, that's something that Duke Power could not demonstrate. Duke Power could not demonstrate that those who had a high school diploma performed any better than those who didn't. So content validity, criterion validity, both of those, you want to make sure you understand those. It is so important in organizations that a particular selection test that you're using either have content validity or have one of the criterion-related validities, predictive or concurrent. Why? Well, number one, for legal reasons, obviously for legal reasons, but number two, doesn't it just make good business sense? I mean, don't you truly want to hire someone based on factors that make a difference, that truly help distinguish top performers from low performers? Reliability here basically says whatever measure you use, make sure it's a consistent measure. If you're giving a person a math test and it says they've got strong math skills, if you give it to them a week from now, it should say that as well. If a week from now it says they got lousy math skills, well, you got something wrong with that measure. Few other things here. BFOQ. In certain situations, it is okay to discriminate based on race, gender, etc. The most common one is religion. For example, Christian institutions, such as Trevecca, hiring Christian faculty members. That is certainly acceptable. You can discriminate in religion. If you think about Hollywood, if you're hiring a character for a movie and they are need to be a male because the role is male, that would be acceptable. Sexual harassment, just briefly here, quid pro quo, the linking of outcomes to sexual favors. a boss telling a subordinate that if you go out on a date with me, I'll give you a raise or something of that nature. That is quid pro quo. That's a pretty clear-cut type of sexual harassment. The one that's not so clear-cut is this hostile environment. That one can actually be quite a gray area. I will tell you the hostile environment is much more common, but it is also much more confusing as to whether it's occurred or not occurred. A couple of last laws here. Americans with Disabilities Act. Don't want to get into all the ins and outs of that. That one's pretty detailed, but basically, a little typo there. It says reasonable accommodation must be made for employees who can perform essential job functions. So if you have an employee, but their disability prohibits them performing the job, okay? If we have an employee, or an applicant I should say, and their disability prohibits them from doing the job, however, with a slight modification to the job, a reasonable accommodation, with that reasonable accommodation, they could then perform the job. Well, we must then consider that person a legitimate candidate. In no way can we hold that accommodation against them unless the accommodation is severe. If it's a significant accommodation, as a company, we could say that accommodation causes undue hardship. It's too expensive, etc. And there's a long history of case law that tells us what are our expected accommodations and which accommodations are not expected. But the point is, if with that accommodation the person can perform the job, then we must consider them a viable candidate. Does not mean we have to hire them, right? But we must consider them a viable candidate. What I mean by we don't have to hire them, well, suppose it's a person who has a visual impairment. They can perform the job if they have a larger computer screen. Okay, well, they're a viable candidate as long as they have a larger computer screen. Doesn't mean we have to hire them, though, because we might have someone who's not visually impaired who's still a better programmer, right? And if they're a better programmer or a better typist or better whatever, we can hire that person. We do not have to hire the disabled individual. The point is we just can't let the disability factor in. Lastly, you see there Family and Medical Leave Act. Individuals must be given up to 12 weeks of family leave without pay and must be allowed to return to the same level job. An employee has to have worked at the organization for a year. There are some caveats to that, but generally must have worked there for a year before the 12 weeks can be taken. The 12 weeks can be taken, remember, every year. Every year an employee can take that 12 weeks, but they can only take it for certain reasons. Like a personal illness or illness of a spouse, illness of a child, death of a spouse, death of a child, caring for a parent, or also death of a parent. But what prohibits most people from taking that full 12 weeks is it is unpaid. And by the way, there's other reasons you can take it. I listed some of the major ones there, but there's also adoption and birth of a child and a few others as well. So I'm not trying to be exhaustive with my list there, but just know that there's only certain reasons you can take it for, and those 12 weeks are unpaid. You do not get paid. And your company can require you to take accrued vacation time. Let's say you have 6 weeks of vacation time. Well, the company can require you to take, of that 12 weeks, 6 of it as your vacation time. So they can force you to do that. Okay. I said Family Medical Leave Act was last. Well, that was actually the last law. I do want to mention now briefly job analysis. I say briefly, it is going to be very brief, but I want to be very clear in saying that job analysis is, hands down, the most important function in HR. Everything else that we will talk about from here on out, recruitment, selection, training, compensation, performance appraisal, all hinges on job analysis. Job analysis is the study of jobs. We study jobs to find out what they're all about. And specifically, this is down here is what we try to find out. We want to know, number one, the task, duties, and responsibilities of a job. In other words, what is the content of a job? And then, secondly, the KSAs. What are the knowledge, skills, and abilities? Okay, so job description, that's one of the things we want to find out when you do job analysis. What is the content of a job? And secondly, we want to find out the job specifications, the KSAs, the knowledge, skills, and abilities. What is the relationship between these two? Well, the KSAs, the knowledge, skills, and abilities, are what a person needs in order to perform the tasks and responsibilities. So when we now recruit people and select people, it's going to be based upon these KSAs. Does this person have these KSAs? When we train people, we're going to train people based upon the tasks and responsibilities of the job and the KSAs they need. When we do a performance appraisal, it's going to be based upon this information. When we compensate people, it's going to be based upon this information. So this job analysis is absolutely essential to organizations. Your book goes into some of the processes of how you do a job analysis, but I want to point you to one last thing here, and this truly is the last thing. Something called ONET, and if you do a Google search and you search just like I have right there, ONET, you will find a site that has been constructed by the federal government where they have done job analyses on thousands of different jobs. And so this is a great starting point for a company to go to see if there's already been a job analysis done for a particular job in the organization. I'm not saying that a company should necessarily just cut and paste from the federal site, because obviously the company, their job may be a tad different, and so they'll need to tweak it. But ONET is a great starting spot. I would really encourage you to go look at ONET and just see some of the really interesting information they have on ONET. Look up your particular job that you do and see if it's on ONET. See if the description fits kind of what you do. They also have salary information on there, and that's always students find that interesting. Alrighty, hope this helps.